Hey everybody, welcome back to the Consumer Warrior Project. I'm your host, John Skiba, and I'm a consumer protection attorney in the state of Arizona. I'm also a Ramsey Solutions Master Financial Coach, where I help people to get out of debt and stay that way. In today's episode and today's video, what I wanted to talk about, something I've addressed in videos and in blog posts and everything before, but something I'm seeing quite a bit in my law practice when it comes to people who are representing themselves in debt collection lawsuits, particularly those people who are being sued by junk debt buyers. Now, junk debt buyers are companies that purchase big portfolios of old charged off debt, and then they file lawsuits on them. Companies like Portfolio Recovery Associates, Midland Funding, Encore Capital, Unifund, Cavalry SPV. These are just some of the big names that you see. And then there's also just dozens of little tiny kind of bottom dwellers all over the country. And they file huge volumes of these types of lawsuits. Now, a lot of people represent themselves in these lawsuits. Actually, 95% of people don't even respond to them. So there's a default judgment rate of about 95%. But the people who do typically represent themselves. I do help clients in defending these types of suits, and they do tend to get better results. But I can tell you that the people who are representing themselves, there's a huge reason why many of them lose these lawsuits, and they tend to lose fairly quickly. And I've been seeing a lot of it come up in my law practice lately with people who are coming in for consultations who've already filed an answer to the debt collection lawsuit. And I wanted to bring up probably the number one thing that I see, which will cause you to lose your debt collection lawsuit so quickly, before it even really gets started, the case will be over. So before I go into what that thing is, let me just go over some procedure with you. So if you've been sued by a debt collector, credit card, junk debt buyer, whoever it is, they go and they file the complaint and the summons with the court, and then they hire a process server to come and serve you with those documents. From the time you get served, you have a specific time period as far as the number of days you have to file a written response. That response is generally called an answer. In most states, you have somewhere between 20 or 30 days. It's important you find out how many days you have in your particular state. It should say that on the summons, though. If you look at the summons, it should tell you how many specific days you have to respond to it. Now, a lot of people will think, I'm going to go ahead and draft a response to this so I don't get a default, which is smart. You want to take that first step. But the problem is the information that people put in the answer is causing them big time problems with their case. And actually, it ends up blowing the whole case up and they lose big time. And here's what people are doing. Instead of responding to the specific allegations in the complaint, because that's all the court really wants to know at this stage. They want to know, look, here's junk debt buyer. They've alleged all these things. Do you admit or do you deny what it is that they're saying? And literally your answer can be you admit it, you deny it. You can go paragraph by paragraph stating I admit paragraph 1, but I deny paragraph 2. That's all it really needs to be. Instead, what a lot of people do is they use the answer as their time to kind of share their side of the story. And their story tends to go something like this. Oh, I got this credit card out, and then during the Great Recession, I lost my job. And when I lost my job, I couldn't make payments anymore, and they wouldn't work with me. I tried to settle this, and so it just I stopped making payments because they wouldn't settle. And then it was sold to them. They sent me a letter. I couldn't pay what they were wanting to settle for. But now I'm willing to pay half, or I'm willing to pay $25 a month until I get this thing paid off. And then they sign their name and they submit it. Well, by filing a response that says those kinds of things, what you have done is really the court saying, look, well, I guess there's really no dispute as far as what's going on. There's not an actual dispute between the parties. You're saying that you owe this debt. Now you're just trying to offer terms. Well, the court is not there to determine whether you can pay it back or you can't pay it back, or how you should pay it back, or set up a monthly payment plan. The court's only there to determine if there's legal obligation on your part as to this particular set of allegations by the junk debt buyer, by the credit card company, whoever it is. And so it's not even really relevant for you to go into, hey, I'm trying to settle this, or hey, I tried to settle it in the past, or hey, I had some kind of arrangement with the original creditor. Those types of things aren't relevant. All you need to respond to is whether you admit or deny what the junk debt buyer is saying. And if you go through there and essentially admit everything, then really there's no dispute. And the next thing you're going to get hit with is something called a motion for judgment on the pleadings, because the debt buyer is going to say, hey, judge, there's no dispute. They admit everything. Just give us what we're asking for. And most judges are going to say, they're right, and they're going to give them everything that they've asked for, and your case is going to be over. And so then people come to me and say, hey, how come I didn't get a trial? How come I didn't get to go in and kind of tell my side of the story? And the reason is because you essentially already admitted everything and your case is over. Now, just so that I'm not misinterpreted here, I'm not saying that you should be anything but truthful when it comes to responding to the allegations of the plaintiff. You're required to do that when you respond to them. But particularly if you're being sued by a junk debt buyer, and they come in and they're saying, hey, that, you had a contract with the original creditor. They're alleging that they own the debt, and they're alleging a specific dollar amount. Unless you have independent knowledge that those things are true, you can honestly deny them. If they're claiming that there's a certain dollar amount that they're entitled to, but you have no idea where that number came from, and in most cases it looks a lot larger than anything that you actually charged to the card, you can deny it. You don't have to explain it further. They're the plaintiff. They have to prove how they came up with that specific dollar amount. It's also true when they say that they were assigned or that the debt was transferred to them. Unless you have some independent knowledge that this actually took place, that your specific account was transferred from the original creditor to this debt buyer, you can honestly deny that. They have to prove that that's the case. And that's one thing with junk debt buyer cases. You'll be surprised at how little evidence they have that they actually were transferred your particular account. So you can go through there, and for most of the things, you can honestly deny them and make them prove their case. And that will help you to avoid this whole judgment on the pleadings thing where, all of a sudden you file your response, and next thing you're getting a judgment in the mail because the court's saying there's really no dispute between the parties. So the answer is not your time to tell your side of the story. It's simply whether you admit or deny what that creditor is alleging. And like I said, in most cases, particularly the junk debt buyers, you can honestly deny a lot of that just because they haven't proven it yet, and they haven't shown you how they calculated damages or how they actually got ownership of the account. So I hope that helps. I hope that a lot of people see this that are being sued by debt buyers, because this is one of the biggest problems I see is that people just give away the case when they don't have to. The judge is not there to determine payment terms or settlement. The judge is only there to determine liability. And once they do that, it's up to the collector to try to set up those terms or settlement, those kind of things. So hopefully that's helpful. That's going to do it for this episode. If you want to learn more about my practice and a bunch of other resources, tutorials, forms, templates that we have, head on over to legal.coach. That's the actual website, www.legal.coach. We have all kinds of stuff there to help you, particularly those who are looking to fight some of these junk debt buyers. I've done hundreds of trials against them, and we have all types of forms, templates, and even video tutorials where I walk you step by step through the entire process. So that'll do it for this episode. Appreciate you watching.